joining us today. We do have a busy day. I know some other committees aren't meeting today, so this kind of balances that out for everybody, gives them something to do today. The first order of business I wanted to do is wanted to work some bills previously heard, or at least discuss and possible final action on those. And so let's bring up, if we can, House Bill 2601. That's Department for Children and Families, and regarding some due process hearings and procedures. If you'll recall, we heard that last week. And with that, a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2601 would establish a registry for child abuse and neglect to be maintained by the Secretary for Children and Families. It also provides for registration and expungement processes on and off that registry, and includes the Office of Administrative Hearings and opportunity for appeals.
Thank you. Committee, any questions? Not seeing any. Then is there any discussion on the bill? You know, I had discussed about making possibly a KDAD's registry as well, but we probably need some further testimony about that and how that process would work. So maybe that's something we could kind of maybe do a trailer bill next session and take a look at that as well. So if there aren't any other points of discussion, then I'll go ahead and wanted to make sure that we could take a look at the amendment I have prepared. We'll have the reviser pass that out. And it came to our attention that if we're going to have these hearings, if we're going to institute this process for the defendants, if you will, to have an opportunity to be heard, that one of the things to reform is that apparently without being represented by counsel currently, you don't have access to look at the records that DCF has. So it seems more fair and transparent and a more fair opportunity for you to defend yourself if you have the ability to review those records, whether you're represented by counsel or not. So of course, DCF can redact who the reporter is and redact other sensitive information. I've seen those redactions before in records. So I thought that that was an important amendment if we're looking at due process in the procedures. So with that, any discussion, or is there a second? Second from Senator Reichman. Thank you. Any further discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries, and we are back on the bill as amended. Is there any further discussion or amendments? Not seeing any, then a motion. Senator Bowser.
Thank you, Madam Chair. I'll make a motion that we pass House Bill 2601 favorably out of committee as amended.
Thank you. Is there a second? Senator Hill. Thank you. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Next, I'd like to take a look at House Bill 2552. And if you'll remember, we heard that last week, and that was a change from it was a brief change to the Kansas Sentencing Commission form, and with that, a summary from the reviser.
Thank you, Madam Chair. House Bill 2552 would require criminal pre-sentence investigation reports and journal entries to be completed and submitted in the form and manner prescribed and approved by the Kansas Sentencing Commission.
Thank you. Committee, any discussion or I'll entertain a motion. Enough time. Senator Titus.
Thank you, Madam Chair. I move that the committee recommend favorably for passage House Bill 2552 and place such bill on the consent calendar.
Is there a second? Is there a second? Senator Bowser. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. With that then, I'd also like to bring up House Bill 2595. And if you recall, that's the Rural Justice Initiative bill. And with that, a summary from the reviser.
Thank you, Madam Chair. House Bill 2595 enacts the Attorney Training Program for Rural Kansas Act. It provides stipends to law students who meet certain criteria, finishing law school and going back to work in a rural area. And then it also provides loan forgiveness to lawyers who meet similar criteria.
Committee, any questions for the reviser or discussion? Senator Titus.
Thank you, Madam Chair. I have an amendment, if the revisers could pass that out. While that's being passed out, I'll explain. So the idea here is that rather than create a new committee and all the bureaucracy that entails, it makes sense to just house this program in the Department of Commerce. There still is a consultation and coordination required with the two law schools as far as developing the rules of the program and selecting, approving applications. So this just gives them a little more freedom to do that, but Department of Commerce, they've already done these sort of programs with the Rural Prosperity Program. So I think we can avoid some of the bureaucracy, and if it doesn't work out, they can come back and we can refigure it. So with that, I would move the amendment.
Thank you. Is there a second? Senator Reichman. Committee, any discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. We are back on the bill as amended. Any further discussion or a motion? Senator Bowser.
Thank you, Madam Chair. And I'll just note that this is rural attorneys, and it doesn't just include Western Kansas, and that's very important to, I think, everybody here. Having said that, I'll make a motion that we pass House Bill 2595 favorably out of committee as amended.
Thank you. Second from Senator Hill. Any further discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. Committee, appreciate the working of some of our bills that we've heard, and we're going to now turn to opening hearings that are scheduled for today. But before we do that, I'm going to take a quick point of personal privilege, and it's my honor and my privilege to get to introduce one of my kids who's here in the gallery today. So if she wants to raise her hand real briefly, and we'll introduce Charlotte. So she's on spring break from college and had fun with a basketball tournament win for her basketball team yesterday. So headed to the big dance, the March Madness. So, but if you'll welcome her, welcome to the Senate Judiciary Committee. So thank you, everyone. As you guys know, we all wear many hats, right? We're not just senators, but family members first, I think. So anyway, thank you for that. And want to open the hearing on House Bill 2747, specifying that courts shall consider certain factors in determining whether a prior violation of law is comparable to any act described in certain driving under the influence crimes when calculating a person's criminal history score under the Kansas Sentencing Guidelines Act. And with that, a brief from the reviser.
Thank you, Madam Chair. Donica Short, Office of Reviser of Statutes. So HB 2747 requires courts to consider certain factors in determining whether a prior driving under the influence DUI-related crime will be counted when calculating a person's criminal history score. The bill amends KSA 216811, the criminal code statute related to determining an offender's criminal history classification. Current law in subsection C provides that certain prior adult convictions or juvenile adjudications for DUI and similar laws are scored as felonies for criminal history purposes if the current crime of conviction is for a violation of involuntary manslaughter by DUI or aggravated battery by DUI. The bill provides that for the purposes of this subsection in determining whether a violation of law of another state, an ordinance of any city, or resolution of any county prohibits any act described in KSA 8.2, 144 or 8.1567, and the court shall consider certain factors. Current law in subsection I provides that certain prior convictions are scored as person felonies for criminal history purposes if the current crime of conviction is for a violation of KSA 8-1602 B3 through B5, leaving the scene of certain vehicle accidents. The bill provides that for the purposes of this subsection, in determining whether a violation of a city ordinance or law of another state would also constitute a violation of KSA 8-1567, the court again should consider those factors. And those factors are found in KSA 8-1567J. They include the name of the out-of-jurisdiction offense, the elements of the out-of-jurisdiction offense, and whether that out-of-jurisdiction offense prohibits similar conduct to that prohibited by the closest approximate Kansas offense. The new language has the effect of requiring convictions under municipal ordinances or similar laws that are based on a broader range of conduct than state law to be counted as felonies. HB 42747 would take effect from and after publication in the Kansas Register. I can stand for any questions.
Thank you. Any questions? Senator Clays.
Thank you, Madam Chair. I'm not sure if this is relevant or not, but kind of feels like a gray area. My understanding of this bill is that it increases the prison sentence for certain defendants by changing how their prior DOI convictions are counted. Because it's increasing those penalties and applying it to crimes that are already committed, would that raise any kind of ex post facto concerns? Reading through it, it looks like it's silent on that point, and I wonder if maybe like just adding a line that says it only applies to crimes committed after the effective date might keep us from having any unnecessary constitutional litigation on that.
So it does not apply retroactively. It's a new DUI. If someone gets their DUI, is it their first, second, or third? And those prior DUIs enhance the sentence, the subsequent sentence, or can. And so this is just kind of adding those municipal ordinances or county violations or violations from another state and seeing whether they're similar to one that we would currently classify as a felony. For example, like involuntary manslaughter by DUI.
Okay, yeah, I think I understand that, but what if they're right now they have a case? Would they be under this or would they not be under this? So, because this gets passed and then, their case hasn't yet been adjudicated, where do they fall in this?
So if I'm understanding the question, after it's passed, it says the Kansas Register. So then, it's looking at past DUIs and using it to calculate score, and based on how those, using the factors, for example, if it's an out-of-state DUI, determining whether that should count to increase the penalty, or the sentencing.
Thank you. Committee, any other questions? Not seeing any. Thank you very much. We do have a couple of bills to hear, so we want to make sure that we can get our work concluded today. So I'm going to ask each conferee to limit their testimony to 2 minutes, please. 2 minutes, and when you have 1 minute remaining, I'll wave the manila folder at you, so please take a look. With that, then, we will have our first proponent conferee, Mark Bennett, District Attorney, 18th District, on WebEx. Please introduce yourself and welcome to committee.
Thank you very much. Mark Bennett, District Attorney in Wichita. Thank you, Chairwoman Warren. This is a bill that was motivated very much by the death of a deputy for the Sheriff's Department here in Sedgwick County. The man who was intoxicated, he was using marijuana at the time. He had 2 prior convictions from municipal courts in the city of Wichita. There was a period of time when the municipal courts laws allowed for a DUI while on a bicycle. I won't get into why that was, but our appellate courts came in later and said that was not something that could be counted as a prior. The irony is, had this man been picked up by a sheriff's deputy out in the county and brought to district court, those two priors would have counted under our existing law. And so this bill is a mechanism to correct that inequity and make it more consistent across the board so that ordinances, other state convictions, et cetera, would all count. To the point, I think Senator Clays a moment ago asked, would this be retroactive? There's case law dating back from the late 80s. A case called State versus Nunn is one of them, but it talks about the difference between substantive and procedural changes to the law. And if passing a law that passes changes the sentence for a crime, that would be deemed a substantive change. And so if it's a case that was pending, say it happened last night, we charge them next week, and this bill passes sometime between now and July, I believe it would be a substantive change. It would not apply to anything that predated the publication of this bill, and that's across the board to any type of change that you all make to the law. If it has the effect of having
1 minute remaining.
Thank you. A substantive change, it cannot be applied retroactively. So I think that's attended to. Bottom line is, this is something that would simply make it consistent so that it shouldn't matter whether you're in a district court or a city, in violation of a city ordinance for a DUI. If you committed an involuntary manslaughter and aggravated battery, either one while drunk or while under the influence of something, or you run from the scene of a crime, of a injury accident, your prior DUIs should count and should count against your criminal history. That's because it does in every other respect. So if you had done that in another county, that would count. We think that it should make a difference that you're in a city. It's a city violation. So in 2 minutes, as quickly as I can, that's, I think, addressing all the concerns. And we appreciate your time. And I know on behalf of the Carter family, we appreciate you giving strong consideration to this. Thank you.
Thank you. Appreciate it. Next, we'll hear from Sheriff Jeff Easter, Sedgwick County, Kansas Sheriff's Association, Kansas Association of Chiefs of Police. Please introduce yourself and welcome to committee.
Good morning. Hopefully you can hear me.
Yes, we can, sir. Go ahead. Please introduce yourself.
Thank you, Chairwoman Humphreys and committee members. My name is Jeff Easter with the Sedgwick County Sheriff's Office. I represent the Kansas Sheriff's Association as the legislative chair. I won't repeat a lot of what DA Bennett has said. We do support this bill. Deputy Sidney Carter tragically lost on October 7th, 2022. While making a call in the county, was struck by a person that was high on marijuana and ran the stop sign and killed her. This person had 2 prior DUI convictions from the city of Wichita, and neither one of those convictions could be used in his trial. During the sentencing phase of this case, the Carter family and the Sedgwick County Sheriff's Office family was astonished when we were told that the 2 prior convictions could not be used against the defendant due to current sentencing guidelines. The result of this was, instead of the defendant facing 144 to 162 months in prison, which was instead sentenced to 42 to 48 months in prison. On top of that sentence, the defendant received 19 months time served since he had been in the Sedgwick County Jail since violating his bond, and then also received the 15% good time credit. So he's going to do less than 24 months in prison for this crime. As DA Bennett pointed out, the irony of it is if the 2 DUIs would have been out in the county and the sheriff's office or any other jurisdiction out in the county charged through district court, they would have been used in his trial. And
1 minute remaining.
Yep. So I appreciate that you're taking this under advisement today, and I strongly encourage you to pass it out. So thank you very much.
Thank you. Appreciate it. Is there any other person wishing to testify as proponent on the bill? Yes, we do have another gentleman. Please come to the podium. Please introduce yourself. Welcome to committee, and make sure you turn in your testimony later today. Appreciate it.
Thank you, Madam Chair and members of the committee. My name is Jerry Carter. I am the father of Deputy Sidney Taylor Carter of the Sedgwick County Sheriff's Office. Sidney was killed in the line of duty October 7th, 2022 in a horrific vehicle crash, which changed our family's life forever. Sidney was only 22 at the time of her death. She worked for the Sedgwick County Sheriff's Office for 15 months in the jail, then was recruited for the road enforcement. After she completed the road academy and her road training, it was her 6th day out by herself when she received a disturbance call. She was heading to the call when another driver failed to stop at a stop sign and hit Sidney's patrol vehicle on the driver's side door. The driver of the other vehicle was driving 85 miles per hour in a posted 55 miles per hour zone when he hit Sidney's patrol vehicle, killing her instantly. Sidney was just starting her career. She always wanted to help others. She had aspirations of becoming a U.S. Marshal. The offender was tested and found to be under the influence of marijuana. The night he was interviewed by an officer, he told the officer he was heading home. When the officer asked what street he was on, he said 53rd Street North. The vehicular crash happened about 5 miles south of where he ran the stop sign at 29th Street North and 135th Street West. He also informed the officer that he smokes marijuana every day. And that night, he had just left his friend's house where they smoked a blunt, and as a reminder, this was his 3rd DUI. Our family was informed at the first meeting that their District Attorney Mark Bennett and District Attorney Aaron Breitenbach that this offender had 2 prior DUI charges in the city of Wichita. One was charged in 2013 and another in 2015. We were also told that these 2 DUIs could not be used because of the Wichita law. The Wichita law took sentencing down from just shy of 15 years to 3.5 years, which I myself did not comprehend. This was his 3rd DUI offense and killed our daughter. However, due to the Wichita law, sentencing, we could only use the 3rd DUI. This is not right in my mind, and this is why we wanted this reform to be fixed. So no other family has to go through the frustration that we went through. The frustration of knowing for 3 years going through the court proceedings that the offender's prior DUIs could not be used. Please pass House Bill number 2747 so other families can receive justice that we did not have the opportunity to. And I know there is no justice that can bring Sidney back to us, but this could help other families get the justice they deserve. And with that, I'll stand for questions at the appropriate time.
Thank you very much. Appreciate that. Thank you for sharing your story today. Are there any other persons wishing to testify as proponent? Not seeing any, then committee, you do have proponent written testimony from Amanda Wood, President, Kansas State Lodge Fraternal Order of Police. Are there any questions for proponents? Not seeing any. Do we have anyone wishing to testify as neutral or opponent on the bill? Not seeing any, then want to thank our conferees today, and we will close the hearing on House Bill 2747. We're next going to turn our attention to the hearing and open the hearing on House Bill 2527, prohibiting courts from assigning a defendant to work release if the defendant is required to register as a sex offender for certain crimes, and prohibiting the Secretary of Corrections from granting an inmate leave from confinement except for specified purposes if the inmate is required to register as a sex offender for certain crimes or is serving a sentence for certain crimes that require registration as a sex offender. With that, a brief from the reviser.
Thank you, Madam Chair. Section 1 of House Bill 2527 amends KSA 216604. This is the statute that describes the sentencing options that the court has when a person is found guilty of a crime. Current law in subsection A11 provides that if the defendant is convicted of a misdemeanor or a non-grid felony, which is the lower level, don't think off-grid, think the lower level non-grid felonies, the court may assign the defendant to a work release program other than a program at a correctional institution under the control of the Secretary of Corrections. The bill adds a provision that would prohibit the court from assigning those defendants to a work release program or serving any portion of a sentence of imprisonment in a work release program if the defendant is currently required to register as a sex offender under the Kansas Offender Registration Act, and the underlying crime for which the offender is required to register was a crime committed when the offender was 18 years of age or older against a victim who was less than 16 years of age. Section 2 amends KSA 75-5267. This is the statute that authorizes the Secretary of Corrections to establish work release programs and educational release programs under which offenders who are in the custody of the Secretary can be granted the privilege of leaving confinement for the purposes of those programs. The bill adds a new subsection C to provide that an inmate shall not be granted the privilege of leaving confinement for any purpose except as described in subsection A1A, B, or C, or as required by law, if the inmate is in custody for an off-grid or non-drug severity level 1 through 5 felony that requires registration as a sex offender, or is in custody of the Secretary for a crime that requires registration as a sex offender, and the crime was committed when the offender was 18 or older and the victim was less than 16, or at the time of being committed to custody, is required to register as a sex offender, and the underlying crime was committed when the offender was 18 and the victim was less than 16. And I can take any questions.
Thank you. Committee, any questions? Not seeing any, then we'll invite proponent, conferee, Representative Dr. Megan Steele, Kansas House of Representatives, District 51. Please introduce yourself and welcome to committee.
Madam Chair, members of committee, my name is Representative Dr. Megan Steele. I represent the 51st District here in Kansas. And I thank you so much for your time this morning to stand in proponent testimony for House Bill 2527. This past summer, a minor in my district received a letter from ks.gov stating that her perpetrator, who horrifically sexually abused her, was going to be granting work release privileges while he was serving his prison sentence, and that this work release could potentially occur at the Kansas State Fair or Kansas Wildlife and Parks. I was appalled by this letter, so I contacted the Director Zamuda of KDOC. We had a meeting with him, and we learned that this is a policy that has been followed by KDOC. And under his leadership, he did prohibit this policy from occurring. But as legislators, we all know that agencies, that directors change, and that policies change. And as legislators, we also know that we need to protect our society, we need to protect our children, and I worked in conjunction with our Sheriff of Wabaunsee County, Eric Kirsch, to help draft legislation that would ensure that those that are convicted of certain crimes, that they are allowed to have work release and educational release on the prison grounds. This bill would just prohibit them from leaving the prison grounds if they are convicted of certain sex crimes. And with that, I'll stand for questions at the time.
Thank you, appreciate it. Do we have any other persons wishing to testify as proponent on the bill? Not seeing any, so we do have, yes. So please come to the podium and introduce yourself. Welcome to committee, and please make sure you turn in your written testimony today.
Madam Chairwoman, members of the committee, my name is Eric Kirsch. I'm the elected sheriff of Wabaunsee County, Kansas. I appear before you today in support of House Bill 2527, and I'll stand for questions. Not long ago, a child in my county was raped. And after we sent him to prison, I promised the child that she was finally safe. The problem was, my promise was a lie. Last year, this young lady received a letter from the Department of Corrections, and the letter stated that the child rapist was now eligible to work outside the prison on account of his good behavior, only 3 years into his 15-year sentence. This letter even stated that the child rapist might be working at the Kansas State Fair. And like you, I serve at the pleasure of the people of Kansas. Government does not exist to protect itself or its own systems. We exist to protect our people, their constitutional rights, their lives, their liberty, and their pursuit of happiness. And liberty, ladies and gentlemen, is the soul's right to breathe. The condition of government, insofar as this matter is concerned, has broken not only a promise to one child, but our promises to all people, and I need you to fix this. This is something that you should fix. This is something that you can fix right here and right now. And frankly, it's shameful if ever our own government participates in bureaucratic indifference or bureaucratic political theater while a survivor of childhood rape sits at home alone, too afraid to go to the Kansas State Fair. This bill is simple. The decision to allow a child rapist out of prison should rest with a judge and only a judge. Not by a policy manual, not by any damn political appointee. A judge of this state, and that judge alone, should have the final say. I need you to vote now as leaders. I need you to vote as people. I need you to vote as parents. Because all these kids out here, they're all looking at you now. And they only have one question. Will you choose to protect the system of government, or will you protect these children? God be with you. Thank you, and I'll stand for questions.
Thank you. Is there any other person wishing to testify as proponent? Not seeing any, then we'll go ahead and open it up for any questions. I do have one quick question. Maybe this is for the reviser. I'm looking at page 3 of the bill, and the bill would apply to, I want to make sure I'm hearing it correctly, to defendants that are currently required to register as sex offenders, and they're required to register as sex offenders because the underlying crime they committed when they were 18 or older, and the victim was a child less than 16 years of age. Just want to make sure I have that correct. Madam Reviser?
Thank you, Madam Chair. Yes, that is correct.
Okay, so you were an adult and your victim of a sex crime was less than 16 years of age, and you're on the registry and you're seeking work release.
Yes.
Okay, thank you. Committee, any other questions? Not seeing any, then we will go ahead and have opponent, Conferee Emily Brandt, criminal defense attorney. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and members of the committee. My name is Emily Brandt. I'm a criminal defense attorney here in the state of Kansas. Specifically, I'm an appellate criminal defense attorney, which means that I represent people who have already been convicted of felonies in the state of Kansas. So almost all of my current and former clients are residents of the Kansas Department of Corrections. And so this bill will unnecessarily impact some of them. I can appreciate that the House Corrections and Juvenile Justice Committee significantly narrowed the scope of House Bill 2527. I think it should be critical and fatal to this piece of legislation that it was brought to this body based on a misunderstanding and misinterpretation of a standard letter sent by the Department of Corrections. I respectfully believe that the moment it came to light that the premise of this bill was based on a fiction, the bill should not have been worked. I do not believe that this bill is based on best practices or evidence-based best practices for people that are residents of the Kansas Department of Corrections, and that the Kansas Department of Corrections is in the best position to make policies regarding work release for its residents. I can agree with the sheriff of Wabaunsee County that constitutional rights, including people's liberty, is monumental. That includes, whether we like it or not, residents who are in the Department of Corrections, people who we may not like what their underlying criminal actions were. 95% of people are going to return to their communities if they entered KDOC, including residents impacted by this bill. And KDOC has told this body that those who achieved a sustained livable wage employment after discharge return to prison a third less often. It is very important that people who are going to return to our communities are able to earn a living wage and are able to be reintegrated into their communities. This bill is going to hamstring the KDOC from implementing best practices and policies for work release. It already has several IMPPs that I've attached to my testimony regarding work release for people that they are managing as sex offenders, which, by the way, is broader than what is in this bill. So I think DOC is already doing what this bill attempts to do, and we should let DOC do that. They are the experts in this industry, and they are going to individually they will individually screen each person they're managing as a sex offender to determine whether or not they're eligible for work release. I believe that 2527 is going to take away the ability of KDOC to implement best practices and evidence-based procedures, and a law based on a fiction and without any evidence-based support is simply not good legislation. And so for those reasons, I stand in opposition of this bill, and I'll stand for questions at the appropriate time.
Thank you. Appreciate it. Next, we will hear from Andrew Crandall, private citizen. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, for the opportunity to be here, members of the committee. My name is Andrew Crandall. I'm a citizen concerned with the necessity of this bill. As previously stated, this bill was born from a concern about sex offenders being on site at the state fair or in state parks of work release. When it was clarified this wasn't the case, the mission creep recharacterized the focus without addressing the flawed premise. The new premise relied on the fear of sex offenders at work release writ large, a sort of, while we're here, we might as well do something approach, and which is no way to construct legislation. The Department of Corrections has policies designed to govern their practices and have essentially full authority to do so without necessitating legislative approval. What makes this topic unique? The suggestion has been that there needs to be no future administration to be able to implement a policy in difference to this bill. What prompted the policy change? Did anyone ask? Does anyone know? No other offender, drug, or violent offender has broad stroke restriction from opportunities to prepare for successful reintegration. When this bill was brought before the House committee, the statistics provided to the House were that the sex offenders recidivate at 36% of the time, which is only true if you calculate for parole revocations, failing to register, drug offenses, et cetera. According to prior facilitators of the sex offender program in the state, reoffense rates typically range between 2 and 4%. What this bill is dealing with is the risk to reoffend in the 12 to 18 months prior to full release. According to an article from the Bureau of Justice Statistics, only 2% of offenders reoffend in the first year post-release. The work release program is designed to monitor and intervene upon risk quickly and effectively. In regards to female offenders, which has been wholly omitted from this conversation, is the fact that do we even know if there are any sex offenders housed at TCF who have offended a person more than once? I think this would be an important qualification to make. If we're having a broad stroke legislative impact on women, do we know if they have the same recidivism rates that men do? Do we incarcerate women? Sorry. The sex offenders who used to participate in private industry and work release went through a stringent vetting process. According to the previous IMPP, before being considered, they had to participate in sex offender programming and complete it. After completion, they could apply for consideration to the program. Unit teams, classification, victim services, sex offender program providers and supervisors, and wardens, and deputy secretary had the opportunity to weigh in on the placement potential of these candidates. If the candidate had a paraphilia diagnosis, they were not considered for placement. If they scored too high on the risk assessment, they were not considered for placement. If they had
That's
not
our
been,
timer, but if you want to conclude, that'd be great.
Thank you. There were strict conditions for anybody being considered for work release as it stood before. I think going back to a policy that gave them the opportunity to be considered, to give the professionals within DOC the opportunity to weigh those candidates individually is better than a broad stroke full exclusion from the potential for work release. For all of these reasons, I think it's important that this body take those things into consideration and do their due diligence to allow KDOC to provide those restrictions and those considerations for the people that they manage. Thank you.
Thank you, appreciate it. Next, we'll hear from Linda Crandall, private citizen. Please introduce yourself and welcome to committee.
I'm Linda Crandall, and in case you notice the same name, that is one of my sons. But the other impetus for my interest in this bill is that I have a son who's in prison. He's not a sex offender, but through him have developed relationships with some of the guys who are there, and I know that they have goals and aspirations for their lives when they get out. But the preparation for that has already started, and I think this whole bill is about preparation for release. I was dismayed. I've been in on the House since the introduction of this bill, and I was dismayed by the lack of accurate information that was given. And even this morning, the information about that case is not right. The letter, I have a copy of the letter. The letter that the victim received said that the perpetrator had received a change in custody, not that he was working work release. And work release and working at the fair are two separate things, but there were not adequate questions and answers in the House to get to the bottom of those things. So I would hope that you all would ask some of those questions before just moving ahead. I'm part of a committee this session that is bringing attention and hoping to undo legislation
1 minute remaining.
that was enacted in 1994. I went back to 2 of the committee members on that Judiciary committee, and where the bill originated. And basically, I wanted to tell them how that bill was playing out and if it was what they intended. Neither of those guys remembered much about it, and they didn't show interest in its current status. And what you do with HB 2527 will have long-lasting effects. 30 years from now, will there be a committee trying to undo a law that is not playing out like you intended? It is important to get this right. The social and financial benefits of being able to work off-site, prison jobs and work release are invaluable. And this would just totally defeat that.
Thank you, appreciate it. Is there any other person wishing to testify as opponent? We do also have, not seeing any, we do also have written opponent testimony from Julie Strick, private citizen. With that, we'll open it up for any questions. Senator Clays.
Thank you, Madam Chair. This is for the opponents. I heard the word fiction several times, and the last person to testify said that there were some facts that maybe weren't well understood, and she's right. I don't really understand what's happening with the story that was told and what evidently is wrong with that. I was wondering if someone could come and explain what that issue is. Also, as a second part to a question while you're up here, I guess I'm thinking about that case that was given to us, and evidently it's a 15-year sentence, and at 3 years they were, again, according to the story, was given work release. But in some of the testimony I read, it talks about how, having work release at least, doesn't happen until 18 months before they are looking to be discharged. So I guess I'm trying to understand that aspect of this also.
Please go ahead and reintroduce yourself.
Emily Brandt, criminal defense attorney. Thank you for your question. I might just pivot, but I think that that's probably best addressed by the letter that the Department of Corrections provided to the Juvenile Justice Committee, which I believe should be part of the testimony on that bill. After House Bill 527 was introduced and heard, KDOC then reached out to the chair of that committee and provided the letter that was sent to the young girl in question and sort of explained that their functions, like work release, isn't even part of like the people that may or may not go to the fairgrounds, and I believe parks and wildlife. And so I genuinely think that this was a misunderstanding of the letter. I also don't believe, and again, you can get a copy of the letter, they have it, that this resident was going to be given work release. It's just a standard letter that says like in the future this person could be given work release and these are the things, da 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 da. As to the sentence time, et cetera, again, I think that if you look at the letter, it is not a guarantee that this person will be released to work at the department, at the fairgrounds or Department of like Parks and Wildlife. It's just a standard form letter that says these could be options available, not a guarantee that this is going to happen or that this is happening, which is why I think that it's just based on a fictitious misunderstanding and misinterpretation of the letter, which is understandable. If you're the victim of a crime and receive this, it's probably very scary. So I don't believe that they were being released onto work release. And again, there's a lot that goes into somebody's sentence. So one, I don't think they were being released onto work release 3 years into a 15-year sentence, but also it could be 3 years into a 15-year sentence minus like if they served a bunch of jail time beforehand. So like maybe they were in DOC for 3 years, but they sat in a county jail for 3 years, like waiting for their jury trial or their case to conclude. So really they're like 6+ years into their 15-year sentence. So they've got jail credit plus prison time, plus maybe good time. So again, I think that this bill is based on just a fundamental misunderstanding of a standard letter by DOC, which this committee should have access to and could get access to. I hope that helps.
Go ahead.
Thank you. Well, I didn't see it in the download, but maybe it's in this other packet. Can you talk a little bit about, and maybe you can't, that letter? Why would they send a letter that is so irritating or harmful or otherwise scary for someone when it doesn't in fact do what it seems to imply that it does? Do you have any insight into that?
I don't. Again, opponent Andrew Crandall might, because I think he might have a copy of the letter based on his position. So maybe that's a better question for him. It could also be simply a better question for DOC. And regardless of what the answer is, I don't believe that codifying this bill addresses whatever this body might have with a standard form letter DOC sends. Codifying this bill is not going to probably change DOC's practice because DOC is not currently letting these people out on work release. So if there's an issue with the letter, I would respectfully submit that whatever that issue is has nothing to do with this bill. If you give me just a minute. Oh yeah, I mean, this letter is, again, I'm not a 15-year-old girl who's been the victim of a sex offense or her parent, so I can't imagine how receiving this letter might feel. But this is a standard form letter that notifies the victim that this resident's custody status was just changed to minimum custody at the correctional facility they were being housed in, which is a determination that KDOC makes. And then it just says that based on that custody status, some offenders may be allowed to work on projects outside the prison fence, but not all minimum custody offenders earn this chance. Projects include, but not limited to, employment with private companies, the Kansas Department of Wildlife and Parks, or the Kansas State Fair. The facility makes the final decision about offender activities. So I don't think that this letter informed anybody that's a particular resident was going to receive work release, was going to be on work release in the near future, just that their custody status may afford them such an opportunity. And again, based on DOC's policies, this offender would not be eligible for them because of their offense.
Thank you. Senator Haley.
I don't know if this is a question for the opponents. I think this is in line with the question that you posed, Madam Chair. Is there a differentiation between, as was brought, that a, quote, sexually violent offense and one that might be statutory? I know you had asked, Madam Chair, is it a bright line test for over 18, the offender being over 18 and that, but I'm wondering if there's a distinction drawn. either currently or in the bill, and I'm not able to see it based on the breakdown, or maybe it's a question for the reviser, between what is a, quote, as testimony was brought by the proponent, a sexually violent offense, as opposed to one that might be considered a statutory offense where there was no violence. Is there a distinction in our law, and would this bill bring that?
Senator Haley, thank you for your question, Madam Chair. I can't answer that. A sexually violent offense is a statutory term. So in the state of Kansas, we have a statutory list of sexually violent offenses. I think it's in 223717, but I could be wrong about that off the top of my head. And so I think that they're just referring to the statutory list of sexually violent offenses, which includes nearly all of the sex crimes. I believe it's just inherent that those sex crimes include violence against a person.
Including, Madam Chair, but not limited to statutory provisions, just the difference in age. That in and of itself is violence per se, or a violent offense per se, where there's just a distinction or a difference in the age.
I think we're going to have the reviser address some of this. Thank you.
Thank you, Madam Chair. So under the Kansas Offender Registration Act, sex offender is a defined term, and it includes a variety of different sex offenses, including sexually violent offenses. So sexually violent offenses are a subset of what can make you a sex offender. So it would include those sexually violent crimes, but it would also include other crimes that are not necessarily considered violent, i.e. lewd and lascivious behavior, things like that.
Thank you. Does that answer your question?
We're getting there, Madam Chair, but I'm not quite. I have to do a little further research, because I just would want there to be a
Or maybe an
distinction
amendment?
between what, what occurred and what consent was, or what, anyway, yeah, we'll get there. I appreciate the response.
Sure. Thank you. Senator Hill.
Thank you, Madam Chair. And you can answer this question, I think, as well as anyone. I'm a little perplexed at the opponent testimony, because it seems like there's a fixation on a letter when what we're really interested in here is what's the law. And my question to you that hasn't been answered yet is, someone that is convicted of raping someone under 16 years of age and is sentenced to 15 years in prison, when would they be eligible to be on work release?
That might be a question for our reviser.
Madam Chair, a lot of that is in Department of Corrections policy. It's not necessarily in the statute. So we could find that. It's possible that Emily knows that because she deals with a lot of those offenders. But otherwise, we'd have to get with the Department of Corrections and get you copies of their policies on that.
And if I may, if this bill became law, would it change when someone would be eligible for work release?
Again, Madam Chair, Senator Hill, I would have to compare. I don't know what the current policy is with the Department of Corrections. So I'd have to get their policy and compare that. Right now, there's no statutory prohibition on these people getting work release. So it would change the law with respect to when they can be on work release or when they can participate in these programs. But I'm not sure that what the current policy of the Department of Corrections is.
Okay, perhaps that helps to clarify a little bit to me, because I've heard conflicting testimony from the opponents, some saying that best practices and evidence-based practices allow convicted sex offenders to be out and getting prepared to be out on a permanent basis. And then I've heard the opposite of that this letter was sent in error and these people are not eligible to be out. So I mean, that's what's made me kind of confused. You can't have it both ways. Either they're not eligible to be out, or they are eligible to be out and can be a problem.
Senator Hill, I appreciate your concern, and Madam Chair, the letter that went out to the victim in this case, again, is a standard letter that goes out whenever any resident's custody status is changed, and so it had nothing to do with this resident's underlying conviction, and so it's not specific about what might be available to people being managed as sex offenders. It's just that this resident's custody status changed to minimum. And so these things could be available, not that they are available. And I have attached 3 IMPPs from DOC to my testimony. And again, the point about evidence-based best practices, and again, allowing DOC to do this, is just that if you codify this, then some of these residents will never be eligible for any sort of work release. And right now, they're not, based on the way that DOC is interpreting its policies and procedures. It could be in the future that we learn more from experts in this field that there is a way to reintegrate these individuals. And so we shouldn't codify a law that would hamstring DOC from doing that. And again, you should be able to get a copy of the letter, but I hope that that answers some of the confusion.
Yeah, I mean, we got to reiterate that my concern isn't what the letter said or didn't say. My concern is what is actually happening. And this term best practices and evidence-based practices, evidence is only saying what has happened in the past. That doesn't say what's going to happen in the future. And so we could have evidence that no one has ever committed a violent sexual crime on work release previously. That's not a guarantee of the future, is it?
Senator Hill, I appreciate that concern. I guess that is true, but again, 95% of people that enter DOC are going to leave DOC. You don't have any evidence in front of you right now that says that these people have ever committed a crime on work release, and I think it does a disservice to these people who are going to serve time, re-enter our communities, and have a fundamental right to liberty to hamstring DOC from ever affording them opportunities to reintegrate into the community and become productive members of community after they've served time for whatever offense they've done.
Sure, one follow-up, then we need to move on.
Okay, yeah, I know we need to move on. So I just want to ask one last thing of you then. If at 3 years this person had followed these procedures and the screening process and had been on a work release, you would be okay with that, yes or no?
Madam Chair, Senator Hill, yes.
Thank you. Senator Rose.
Thank you, Chair. What information can you give us regarding recidivism rates? What is the recidivism rate, generally speaking, for all sexual offenders? And what is the rate for offenders who committed a crime against an individual that was under 16 years of age? And also the recidivism rate for offenders who have gone through a work release program.
Senator Rose, I appreciate your question, and Chair Warren. I'm not going to give you answers to those because I don't have them, because again, I'm not an expert in the field, which again, I think is just the problem with this bill. It was brought to us without any of this evidence-based information. I really think we need that to make good policy for the state of Kansas.
Chair, I'd like to ask that question to Andrew, see if he has that information.
Please reintroduce yourself.
Andrew Crandall, opponent of this bill. According to, find it, a multinational meta-analysis of sex offender recidivism rates, reoffense rates over the past 80 years tend to be in the range of 7 to 8%. And I want to clarify, when we talk about recidivism, it's different when we talk about repeat sexual offending from the general reoffense or the general recidivism rates, which would include parole violations, coming back into the facility for any reason. So when I say 7 to 8%, and that's after 9 years of being in the community offense-free, only 7 to 8% of sexual offenders commit a new sexual offense. And the authors of that study, and this is from the Journal of Criminal Justice, May of '24. So according to those authors, this also does not account for the past few decades where that number tends to continually be coming down. So the 7 to 8% is an aggregation over the course of that 80 years, but over the past few decades, that number is even smaller. And then the article that I mentioned, the Bureau of Justice Statistics, a lot of S's, from 2019, only 2% of offenders reoffend in the first year post-release, which is really that focused area of time that these guys would be on work release. So respond to Senator Hill's question from earlier, there's no consideration for work release, according to the IMPP, for anybody who's greater than 18 months or 24 months prior to their offense. So somebody who's at 3 years of a 15-year sentence would not be considered per IMPP. So it would only allow for them to be considered once they've completed the program, been vetted, all these things, and are now within the last 24 months of their sentence. Does that answer your question, sir? Okay.
Thank you. Committee, any other questions? Not seeing any, then thank you very much for the testimony from our conferees today. And we will close the hearing on House Bill 2527. That leaves us with one hearing remaining, and we'll open up the hearing on Senate Bill 478, increasing the criminal penalties for assault or battery of a utility or communications employee. With that, a brief from the reviser.
Thank you, Madam Chair. Section 1 of Senate Bill 478 amends KSA 215412. This is the crime of assault. Current law provides that just a classic assault is a Class C person misdemeanor. This bill would provide that assault of a utility or communications employee while that employee is engaged in their duties would be a Class B person misdemeanor. Section 2 amends KSA 215413. This is the crime of battery. Again, current law provides that just a classic battery is a Class B person misdemeanor. This bill would provide that battery of a utility or communications employee while they're engaged in their duties would be a Class A person misdemeanor. As used in both sections, a utility or communications employee means an employee of an entity that provides electricity, natural gas, water, wastewater, telecommunications services, or internet access services. And I can take any questions.
Thank you. Any questions? Senator Haley.
Was there a bed, thank you, Madam Chair, was there a bed space impact on this?
Madam Chair, I can double check. I suspect there's probably not because we're talking about misdemeanors here. So any penalty would be served in jail, not in prison. And the Sentencing Commission just does bed space impacts when it's going to impact the KDOC numbers.
Thank you, Ms. Scott. Thank you, Madam Chair.
Thank you. Any other questions? Not seeing any, then committee, we will hear from proponent conferee Reagan McLeod, Director of Government Relations, Kansas Electric Cooperatives. Please introduce yourself and welcome to committee.
Thank you, Madam Chairman and members of this committee. Reagan McLeod with Kansas Electric Cooperatives. Although I have the honor today to kind of represent the entire utilities industry, so I will be pretty brief. I think you know, for those folks that serve on utilities or have in the past, getting all of the utilities on the same page is a commendation to the sponsors of this bill and the chair. So the cat's hurting themselves on this one, Madam Chairman, so I'm happy to represent everybody. I think the reviser did an excellent job of explaining the details of the legislation, so I'll try to focus a little bit more on why it matters to the utilities industry. When we're talking about utilities workers that are being assaulted or battered, often they are in high-pressure outage situations where tensions are high. Often you're knocking on doors at 2 in the morning trying to get the power back on or get the gas back flowing. There's a great example in Texas after Hurricane Beryl where there was a lineman threatened at gunpoint. Texas and their legislature reacted after the fact, but I think that this legislation gives our legislature the opportunity to get ahead of it and react right now rather than waiting for a bad example to react to. I know that there's probably going to be some questions about why a special class of victim is necessary under this legislation, but Kansas already recognizes this logic under KSA 215818, which elevates protections for attacks on critical infrastructure. If you were to speak to any of my membership's CEOs, that manage a variety of amounts of employees, they would say that their most critical asset is their people that work underneath them. So by extension, critical infrastructure includes those that work on it on a day-to-day basis, especially at times of critical outages. So Senate Bill 478 simply extends that same reasoning to the people that operate on critical infrastructure. I also want to just mention, too, I want to thank the sponsors of this legislation. It has bipartisan support. I also will say that our friends from AT&T have a possible amendment that they will distribute to this committee that includes contractors within the legislation. But I think that the bipartisan support on this it says something about the validity of the legislation, and I hope it's something we can take up in the future. So on behalf of the utilities industry as well as KEC and our members, thank you, Chairman, for the opportunity to testify today, and I appreciate it, and I'll stand for questions at the appropriate time.
Thank you. Good timing. The alarm was about to go off. So, it's nice to see utility people here in Judiciary Committee, and you got your joke in. You always like to start off with a joke. So you said the cats herded themselves. So appreciate that. Next, we will hear from John Garrettson, Assistant Business Manager, IBEW Local Union 304. Please introduce yourself and welcome to committee.
Thank you, Madam Chairman and committee members. My name is John Garrettson, Assistant Business Manager, IBEW Local 304, and also a 43-year utility employee. So in full transparency, 19 of those years I spent in the union office, which really gives me a good insight because I have the field experience for the confrontations I've had with the public, and then also in my position hearing what goes on in a much broader state. Ironically, I gave you written testimony, so I won't beleaguer that. But ironically, this morning I was telling my new boss that I was coming down here to testify, and so he told me a couple of stories. And one of them, I think, just hit the news on Friday. There was a PG&E crew working. They set up a 100-foot boom so they could work from one side of the street to the other. While they were doing that work, the customer that lived under the line they were working on came out and started shooting at them. Hit one of the linemen in the arm. SWAT was called in. They took the assailant down. 3 shots to the chest, and he still lived. So he was a tough one. That's important to you because one of those linemen came out of Local 304, is a construction lineman working in PG&E. So there's stories that I can tell you in my written testimony and how that hits both in Kansas and in the nation. In the last year and a half or so, we had a journeyman gas worker working in central Topeka. In my testimony, I say we work in every area, every neighborhood, whether it's high crime or not, right? And so he's in central Topeka doing a gas turn-on. 2 gang members get into a skirmish and they pull out weapons. He was able to retreat, get back to his vehicle, and call police. So it is real. There is confrontation. My boss also told me today he was a troubleshooter for Evergy, and he was involved in 3 different drive-bys where he took shelter behind his truck while this action was going on around him. So detracts from the ability that we have in order to make sure that we're handling the hazardous material that we do every day between electricity and gas. So I stand as a proponent, and I would certainly urge the committee to pass this legislation. I'll stand for questions as appropriate.
Thank you, appreciate it. Committee, we have a couple of proponents who were listed as in person who are going to be written only, but before we get to that, is there any other person who wishes to testify in person as a proponent? Not seeing any, then we do have proponent written only testimony would be from Senator Ethan Corson, Kansas State Senate, District 7, from Jake Lowen, Kansas AFL-CIO, from Laura Lutz, Government Affairs, Kansas, Evergy, Patrick Vogelsberg, Manager of Government Affairs, Kansas Gas Service, Darren Miller, President, AT&T, J.R. Behan, ITC Great Plains, Bart Armstrong, President, Colorado, Kansas Division, Atmos Energy, and Stephen Cowan, Black Hills Energy. With that, any questions for our proponents? Senator Titus.
Thank you, Madam Chair, and whoever would like to take this for the proponents would be fine, but do we have any record of prosecutors being unwilling to move cases forward when utility or communication workers are assaulted?
Thank you, Madam Chair, and Senator Tyson Senator Titus for the question.
Could you just
I do not
reintroduce
have it
yourself
off
real
of-
quick? Just reintroduce yourself
Oh,
real quick. Thanks.
Excuse me. Reagan McLeod, Kansas Electric Cooperatives, today on behalf of all the utilities. I don't have that off the top of my head, and it's not included in my testimony, but I would be happy to look up specific examples of a prosecutor unwilling to prosecute an issue like this. I'm sure it exists somewhere throughout the country. You're probably looking more for a Kansas example, so I will definitely research that and try to provide it to you as soon as I can.
Thank you.
Thank you. Committee, any other questions? Senator Shane.
Thank you, Madam Chair. I know that there's been times that my yard felt like it was assaulted and battered, but that's never an excuse to have a negative interaction with a utility employee. And I recognize that there are more opportunities to be at risk in that situation, and people have got to the point of insanity. I mean, I think it was in Parkville, Missouri, there was a guy that shot at a snowplow because he was angry about the plow conditions of the road. And so recognize that your employees and your contractors put themselves, unfortunately, in situations that put them at greater risk sometimes. So look forward to supporting the bill.
Thank you. Senator Clays.
Thank you, Madam Chair. I am one of the co-sponsors of this, although I will admit that Senator Corson did the yeoman's work on this, and I'm really happy to work with him. He did a great job on this. I just want to point out to everybody that this isn't any kind of special treatment that Kansas already provides enhanced penalties for assault and battery against law enforcement, school personnel, healthcare providers, mental health employees. So this really is just filling in a gap, I think, in the statutory framework. You know, from a rule of law perspective, there's no principled basis to protect a school nurse, but not a lineman that is restoring power to that school. So obviously I'm in favor of this. I think it's a good bill. I think the proposed amendment is something that I would probably also support. I didn't notice that small gap in there, but nonetheless, I hope everybody takes a close look at this and sees how important it is. Thank you.
Thank you. Senator Hill.
Thank you, Madam Chair, and thank you for the testimony today. And I want to reiterate some of what my colleagues have said, the importance of keeping people in their workplace safe. And we have talked about this previous years about making that a broader category, that anyone who's involved in the process of completing their work and is assaulted is moving that penalty up. But one thing I did want to quick point out, that there was a lot of instances talked about the use of firearms, and I recognize that that's is a scary thing, but it's actually a different category. That would be aggravated assault, as the way I read the legislation, which is actually a felony. So we don't want to say that if you shoot at your utility man, it's only a misdemeanor, class 6 or 7 or whatever it is. So wanted to point that out. Thank you.
Thank you. Committee, any other questions? Not seeing any, then do we have any persons wishing to testify as neutral or opponent to the bill? Not seeing any, then thank you, and we will close the hearing on Senate Bill 478. Committee want to say that this concludes our work for today. However, we do have 3 bill hearings tomorrow, and since tomorrow is our last day to meet as a committee and discuss and possibly final action on bills, want to ask you to today, if you can anticipate any amendments, get those started so we can have an opportunity, if there's opportunity to do that tomorrow, to work the bills. And they are House Bill that we're going to hear tomorrow, House Bill 2651, they're on your agenda for tomorrow, House Bill 2537, and House Bill 2613. So would like to entertain the possibility of possibly working those tomorrow. It's not our usual practice, but that's why I wanted to give you the heads up today to work bills the same day we hear them. With that, then, thank everyone for their attention and their work, and we will see you tomorrow. Meeting adjourned.